Welcome to Meet the Press Now. I'm Kristen Welker on an historic day in Washington as the United States Supreme Court weighs the limits of presidential power. At the same time as the former president sits in a criminal courtroom in New York for day 3 of testimony in his hush money trial. And as he faces new legal peril in Arizona after being named an unindicted co-conspirator in an indictment tied to his team's efforts to overturn the 2020 election. We will get to the developments in New York and Arizona in just a moment, but we do have to begin right here in Washington. That's where the Supreme Court appears likely to reject former President Trump's broad interpretation of presidential immunity. But the court may send the question of presidential immunity back to the lower court, delaying his trial on charges he tried to overturn the last election until after the next election. As lawyers for Mr. Trump argued that he had near total immunity to act as president, they were pressed by some of the court's liberal justices about the potentially alarming implications of that argument.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that.
But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. Again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad.
Now, lawyers representing the Justice Department were pressed by the court's conservative justices about their view of criminal liability surrounding the actions of a sitting president, raising concerns that it could open a Pandora's box of litigation, impairing a president's ability to do his or her job.
Do you really, did I understand you to say, well, if he makes a mistake, he makes a mistake. He's subject to the criminal laws just like anybody else? You don't think he's in a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution.
Now, several of the justices today seemed acutely aware of the historic weight of this case and the precedent they could set for the powers of the presidency itself. There seemed to be widespread agreement among the justices that no president is above the law. Now, as he arrived in court in New York this morning, Mr. Trump addressed the case before the High Court.
I would have loved to have been there, but this judge would not allow that to happen. But the argument on immunity is very important. The president has to have immunity. This has nothing to do with me. This has to do with a president in the future for 100 years from now. If you don't have immunity, you're not going to do anything. You're going to become a ceremonial president. You're just going to be doing nothing. You're not going to take any of the risks, both good and bad.
Joining me now from outside the Supreme Court, NBC's Ken Delaney, and also with me, Supreme Court expert and co-founder of SCOTUS blog, Amy Howe, former attorney for former President Trump, Tim Parlatore, and Barbara McQuaid, a former U.S. attorney and NBC News legal analyst. I want to thank you all for starting us off on this hugely significant and historic day, as we said. Ken Delaney, let me start with you. You are outside the courthouse. Take us through the key takeaways today. Was the questioning more or less what you were expecting it to be?
Yeah, Kristen, I have to say, I fully expected that a number of conservative justices would find some reason to see some level of presidential immunity for official acts, and that's what I think they signaled today. On the other hand, they are not buying the notion that Mr. Trump has absolute immunity and therefore this case must go away. To the contrary, in fact, Mr. Trump's own lawyer acknowledged that some of the allegations in the indictment went to acts that were purely private acts, not official acts. That was an interesting moment during the hearing. Apologies, we have a heckler here. But clearly, a potential majority of conservative justices were very concerned about the idea that a president would have no immunity whatsoever, which was the position of the D.C. Circuit Court. So that's where this looks like it's heading. And if, in fact, they decide that there is some level of limited immunity for official acts, but the case can still go forward, they may have to throw it back down to Judge Tanya Chutkan and have her decide which of the allegations in the indictment are official acts and which are private acts. And the result of that is going to be the case isn't derailed, but it's significantly delayed, Kristen.
Ken, incredible job reporting and powering through that heckler behind you. I'm going to give you a few seconds, and hopefully that person will settle down a little bit. Let me turn now to you, Amy. What were your takeaways today? And kind of pick up where Ken left off, this disparity that Mr. Trump's lawyers were making between official acts that are done in the capacity of the president, in the name of the executive branch, and actions that are done in a personal matter.
Yes, and he conceded that some of the allegations in the complaint, he disputed sort of the underlying facts, but he conceded that some of them were private conduct. Some of them, he said, were official acts. And, as Ken said, some of the justices seemed to be ready to maybe just draw that distinction and maybe kick it back to the lower courts. But other justices were concerned. The Supreme Court only hears about 65 cases a year. So in almost every case, they're concerned that they're not just deciding that particular case before them, but they're deciding cases that will set rules for years to come. And that was, sort of true to the 10th degree in this case. Justice Kavanaugh, Justice Gorsuch said, this is a ruling for the ages. And so they may want to set some broader rules to govern future cases involving presidential immunity. And so the question is sort of, if they're going to reject the D.C. Circuit's decision that says that presidents never have immunity, but they're going to say that reject at the same time Trump's sweeping view of presidential immunity, what is the rule going to be that they arrive on in the middle? And that's what really wasn't clear to me coming out of the arguments today.
Tim, what do you make of that? And there does seem to be broad agreement that the justices were very skeptical of former President Trump's argument that presidents should be entitled to broad immunity. However, even if they come up with a narrower interpretation of the law, that could still be a win for Mr. Trump.
Oh, sure. I mean, I've always looked at this as, you have one side saying no immunity, the other side saying total immunity. The reality is going to be somewhere in the middle. It's going to be some type of qualified immunity. And, whatever they are going to rule on, if they cut it up and they say, OK, this is the test, they're going to send it back down to the district court to have further proceedings and potentially even evidentiary hearings to decide what parts of this indictment can stay and what parts get excised out. And I thought it was interesting that the special counsel actually kind of telegraphed that Jack Smith may, in the interest of speed, decide to cut the indictment himself and avoid the trial, avoid that hearing so he can get faster to the trial.
It's such a fantastic point. Barbara McQuaid, pick up on that point, if you would, this suggestion by one of the justices that why not make this a narrower case so that Jack Smith can move forward more quickly. And if this does get kicked back to the lower courts, I mean, that's a real victory for Mr. Trump in the sense that this may not go to trial before November.
Yes, and that is an option that Jack Smith has. I think that as a prosecutor, you always want to go to trial with all of your evidence. You don't want to try a case with one hand tied behind your back. And so I think in the first instance, he's going to try to have all of it, to have his cake and eat it too. But if he sees that there is some evidentiary hearing and it's held that some of these allegations in the indictment are clearly private acts and some others are clearly official acts, if he can eliminate the official acts and have a clean case, that may be one option. For example, today there was a question about a conversation with Vice President Pence. If that is an official act, how do you decide when it's a private act versus when it's an official act? But I think there's still an argument for Jack Smith to argue that even those things, which might under some circumstances be seen as official acts, are not always official acts. For example, one of the lines that was suggested today by Michael Dreeben, who was arguing for the special counsel, is one way to think about this is acts that are done by the office holder versus acts that are done by the office seeker. And so even in those conversations between Donald Trump and Mike Pence as the vice president, were about campaign issues, not about governing. And so I think that that is an option that Jack Smith has in his back pocket, but I think he doesn't want to play that option until it becomes absolutely necessary.
I want to play a little bit of an exchange between Chief Justice Roberts and the special counsel's attorney, and then Ken, I will get your reaction on the other side. Let's listen.
The Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement, because the fact of prosecution was enough to take away any official immunity. The fact of prosecution.
I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today.
Ken, it's a significant exchange because it underscores what Amy was talking about here earlier, this notion that however the justices decide, the implications are massive, not just for former President Trump, not just for the case that he is facing, but for all future presidents, Ken.
No, that's absolutely right, Kristen. And, you know, many of the justices talked about that. They didn't want to talk about this case in particular. They said, look, we're looking at this for posterity. And what you heard there from Justice Roberts was real disquiet and concern over the broad D.C. Circuit ruling that found no immunity whatsoever. And what was interesting is that even Michael Dreeben, the lawyer for the special counsel, acknowledged that there are some issues, some things that a president does that probably aren't prosecutable under Article 2 of the Constitution. For example, foreign policy actions, overseas actions, things relating to foreign governments. But many of the conservative justices disagreed with him when he said there is no immunity. They clearly had trouble with that idea and thought that there should be some for official acts, and they were grappling with exactly what that would look like. And I just want to play off something that Barbara said about, you know, deciding which evidence might come out if some of it's official acts. This is a conspiracy case. So what Michael Dreeben said during the hearing is that it's possible that you could put on all the evidence and then instruct the jury that only the private acts are the crimes, but you still put on the evidence about, for example, Mr. Trump's, efforts to influence the Justice Department, which many people think could have been an official act, but still was in furtherance of the conspiracy to overturn the election, or his communications with Mike Pence. You could still let the jury see that evidence, but then instruct the jury that official acts aren't crimes, but private acts are.
Tim, what's your take on that and just how complicated it is to draw that distinction between official acts versus private acts?
It is very complicated. It's something that, when I was involved in this case, going to Barbara's point, she hit it on the head because we were looking at it as, the difference between candidate Trump and chief executive. And, what parts, are within his role as the president. And, one of the themes that we were, kind of teasing out at the time was, if a president who's at the end of their second term has credible information about fraud that would have changed the results of the election, let's say it's President Obama in 2016, would we want him to be calling the DOJ saying, I want you to investigate this? Would we want President Obama to be calling Georgia and doing all those things? And that, when you kind of paint it in that light, that kind of gives you a much more clear delineation between what is the chief executive doing and what is the candidate doing when you actually separate them into two people. But when it's one person, it's so difficult to figure out.
Amy?
Yeah, Justice Jackson actually also talked about this. She said, these are difficult line drawing problems. She said, but, if we decide that there's no immunity, we don't have to make these decisions.
Let's play a little bit of the sound that I believe you are referencing. This is Justice Jackson weighing in on that very point that Amy's discussing, how challenging it is to draw that line.
You seem to be worried about the president being chilled. I think that we would have a really significant opposite problem if the president wasn't chilled. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority could go into office knowing that there would be no potential penalty for committing crimes. I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
Amy, what do you make of that line of questioning?
She was really trying to push back against one of the former president's main arguments, which is that if you do not have blanket immunity for an official act, that everything a president does will be affected by this idea that he or she could be prosecuted after they leave office, and in particular that it could be this sort of cycle in which there could be political retaliation by the next president. And she said, doesn't it work the other way around?
What about that argument? As you were thinking about this case, how much did you grapple with that idea, the implications of the opposite being true, that you can give someone broad immunity, but the implications of that are potentially a very slippery slope?
No, I agree with that completely, because you want to have a certain level of immunity. You don't want the successor to say, I disagree with the drone strikes that you ordered overseas, and therefore I'm going to prosecute you. But at the same time, there has to be some level of deterrence. And it was interesting, the hypotheticals that they were placing today to the advocates, I thought it would have been kind of interesting had they instead gone to Mr. Sauer and given him hypotheticals that closely relate to allegations that the Trump campaign has made against Joe Biden and Hunter Biden, and watch John Sauer try and defend, oh no, it'd be perfectly fine for Joe Biden to take money from Hunter and then do all this stuff overseas. And I think that because ultimately that's what the justices are really trying to do, is not just figure out what should be the rule for Donald Trump, but what should be the rule for all presidents.
Barbara, pick up on this, and I know you can't see into the future, but if you had to infer from what we heard from the justices today, there is a lot of suggestion that it seems like they may be poised to find a very narrower interpretation of immunity, but also that it could get kicked back to the lower courts. What would the implications of that be? And do you anticipate that's what happens?
I don't know. The court is supposed to decide only the case that is before them. And so when Justice Kavanaugh says things like, I'm fine with this case, I'm thinking about other cases that we're writing for the ages, for history here. I mean, certainly they want to draw the line in the right place in this case, but they don't really need to decide cases that are not before them. And so if they look just at this case, and the charges in this case about Trump acting as a candidate, I don't think they need, it's really a difficult question at all. But I do agree that if they decide they need to draw these lines about what is and is not an official act and which of these allegations falls on which side of that line, I'm confident that Judge Tanya Chutkan can probably do that pretty quickly and get the case back on track. The concern I would have is if Trump decides to appeal that decision and the court allows that. That is what would derail this case till after the election.
Ken, let me go back to you. What are the potential implications for the other cases that former President Trump is facing, including, of course, the classified documents case, which is also being brought by special counsel Jack Smith?
I mean, it does have implications for the classified documents case, but I think those are limited because a lot of the conduct in that case, Kristen, is alleged to have happened after Mr. Trump left office. I think it would really have implications for the Georgia case, which alleges a lot of the same conduct that is alleged in the Jack Smith case. And so many of those things will be construed by Donald Trump and his lawyers as official acts, and depending on how the Supreme Court rules, that could impinge on those charges. But the biggest impact, I think, is just to delay this seminal election case that Jack Smith has brought against Donald Trump related to January 6th. It seems very remote at this point that case can get to trial before the election.
Very quickly to both of you, Amy and then Tim, what will you be watching for moving forward as we wait for this decision by the Supreme Court?
I'm going to be looking at exactly what the court says in its opinion, and then when they issue it. You know, the justices have not shown an inclination to move particularly quickly on this one compared, for example, to the election case that they heard oral argument in February and then issued a decision a month later. I don't expect them to move that quickly in this case.
Tim, how about you? Do you think they'll move quickly in this case?
I think because of the gravity of the situation, they probably will take their time. I don't think that the Supreme Court is moved by Jack Smith's schedule. They're going to do it in their schedule. And then I do think it is going to end up with, more hearings and, as Barbara just said, probably an appeal. But here's another thing is that if they end up severing a good piece of this out, saying that's official acts, that's immunity, do they then file a follow-on motion saying, well, that negatively impacted the grand jury proceedings because you presented a whole bunch of immune conduct to the grand jury? So it definitely opens up a lot of things where even if he loses, the argument of the absolute immunity, which he almost certainly will, he's going to win the clock.
All right. Well, thank you for a fantastic opening segment on a very big and complicated day. We really appreciate it. Amy and Ken, thank you both, Tim and Barbara. Stick around for us because we have more historic legal developments to get to coming up. New testimony, new revelations, and new allegations in the former president's criminal hush money trial as he escalates his attacks on the court. Plus, all the president's men. An Arizona grand jury has criminally charged more than a dozen Trump allies for attempting to overturn the 2020 election, while also naming the former president himself as an unindicted co-conspirator. Stay with us. You're watching Meet the Press now. Welcome back. As some of the former president's attorneys were arguing before the Supreme Court, Mr. Trump and other members of his legal team were back in the courtroom in New York City as David Pecker, the former publisher of the National Enquirer, resumed his testimony for a third day. Pecker acknowledged the catch-and-kill scheme surrounding a former Playboy model's relationship with Mr. Trump was intended to help Trump's candidacy in 2016, saying, quote, "We didn't want the story to embarrass Mr. Trump or embarrass or hurt the campaign." Now, just last hour, Trump's legal team began their cross-examination of Pecker. Joining me now is Rahema Ellis outside of the courthouse. Rahema, thank you so much for joining us. So what were some of the other big takeaways from David Pecker's testimony today?
One of the things that David Pecker was asked, it was about paying Karen McDougal, for her story and this catch and kill kind of scheme that seemed to be so regular, that was just so ordinary. And he was asked the question of whether or not he was aware that expenditures to influence the election of a campaign were illegal. He said yes. And that seems to cut to the heart of what this is all about. Donald Trump is, even though this Karen McDougal was not someone who's mentioned in this particular indictment, it's Stormy Daniels who is. What David Pecker did was he seemed to establish that Donald Trump was very much involved in how his money was spent and that Michael Cohen was an intermediary in all of that. David Pecker made mention that when he and Michael Cohen went to lunch, Cohen couldn't even pay for lunch because it wasn't authorized by Donald Trump. And they both knew it. Michael Cohen knew it. David Pecker knew it. And earlier in his testimony, he had mentioned that Donald Trump was something of a micromanager, if you will. He was very much involved in his finances. So this might cut to the heart of a lot of what the prosecution is trying to present in this case about Donald Trump, falsifying his business records to cover up an adult film star's payoff, if you will. That's where they're alleging there's a crime, not the payoff itself, but the falsifying of the business records.
The first of a number of critical witnesses that we anticipate we will hear from. Let's talk about the defense a little bit. Rahema, what has the defense been focusing on in their cross-examination so far?
One of the things that we noticed from the documents that our reporters are sharing with us of what's going on in the courthouse is the word that it seems to be kind of rapid fire questions of yes or no. And one of the things that David Pecker was establishing was that this was not something unusual for them to take a story that was unflattering about a celebrity, buy it, and then not run it. They talked about doing it with Arnold Schwarzenegger. He said he did it with Tiger Woods, if you will. And so basically, I guess the defense is trying to say that this was sort of standard operating procedure with David Pecker, and it's not to be considered something extraordinary that also happened with Donald Trump.
We are waiting for Judge Merchan to decide if Trump violated his gag order, and prosecutors laid out more potential violations today. What did they say? And Rahima, when are we expecting the judge to rule on that gag order?
Well, they started talking about this morning, and that was outside of the jurors being present in the courtroom. And the prosecution brought up 4 more instances of where they alleged that Donald Trump violated the gag order. The gag order basically says you can't attack witnesses. One of them that they brought up was an interview that Donald Trump had with a Philadelphia TV station when he called Michael Cohen as a convicted liar. And that's sort of saying bad things about a potential witness, according to the prosecution. And so they're saying that Donald Trump should be held accountable for this. Now, what does that mean? They're asking for $1,000 per violation. They are not asking for any incarceration for him, but $1,000 for each violation. The judge has simply, it seems, to take it under advisement, not saying when he will rule.
All right, Rahima Ellis, thank you so much for covering all of the angles for us in a very busy day in a Manhattan courtroom. Really appreciate it. I now want to bring back our legal experts, Tim Parlatore and Barbara McQuaid. Barbara, let's start with you. What were your big takeaways from David Pecker's testimony today?
Yeah, I thought that he held himself up pretty well. I mean, I think some of the issues here are going to be what is business as usual and what's normal. And I think if you're a juror, an ordinary person, the idea of this checkbook journalism and this idea of catch and kill and payment of hush money sounds like a pretty foreign idea. Most of us are not dealing with those kinds of issues on a daily basis. And so the idea of normalizing that behavior, I think, sounds very strange to most of us. But I think, by acknowledging that these things happen with other people as well as Donald Trump, David Pecker is coming across as a credible witness. And what really matters here, I think, is that meeting that happened on August of 2015, where they hatched this plot about not only pushing false claims about Donald Trump's enemies, but preventing these claims from going forward about Donald Trump. But importantly, the idea that there would be these illegal campaign expenditures as part of all of that. That's what makes this unlawful and what differentiates it from cases like Tiger Woods and Arnold Schwarzenegger and others.
Tim, one of the big questions hanging over this entire trial is the quality of the witnesses. Right. For example, Trump has already started to paint David Cohen as, for a long time, has said he's a liar. He's someone who is not someone that you can trust. How does David Pecker come across as a witness? How do you anticipate the jury is viewing? As Barbara said, some of what he's talking about is just totally unrelatable. Right. But from the perspective of whether he's credible, how do you think he comes across?
And obviously I'm not in the room,
you're not in the room,
so I don't see his demeanor. But I mean, from everything I've heard, he does sound credible, and it does sound like, I mean, if I were cross-examining him, I would not be trying to attack his credibility. What I would be doing is kind of exactly what it sounds like they're starting to do, is to place it all into context. And I would go through, okay, you're familiar with all of these things. Do you know anything about the payments to Stormy Daniels, or how that was, how that was put in the ledger? No? Okay, so you don't know anything about the charge conduct. But then you do that, normalization, and how many other people have they done this for? The fact that you go on about all these false stories that were put out against political rivals, but that also is normal. And talk about the Steele dossier and things like that, fake stories about Donald Trump, and you kind of bring all that in. I don't think you attack his credibility.
Let me hit the pause button for 1 minute. Here comes former President Trump. Let's go into address reporters.
Thank you very much, everybody. Today was breathtaking. This room, you saw what went on. It was breathtaking. And amazing testimony. This is a trial that should have never happened. This is a case that should have never been filed. And it was really an incredible day. Open your eyes. And we can't let this continue to happen to our country. On another matter, the economy has just been reported to be doing very badly. The stock market's way down, and some horrible numbers came out. including very high numbers on inflation and in particular gasoline at $7.50 in California. That usually leads the way. It's going to happen here too. And very importantly, as you look at the various colleges all over the country and beyond colleges, because it's happening in other areas too, you see what's happening on the front having to do with Palestine and Israel and protests and hate, anger. Biden is sending an absolutely horrible message. Horrible, horrible message. He has no idea how to message. He can't speak. He can't put two sentences together. He doesn't know what to do. This is not our president. This is somebody that shouldn't be doing what he's doing because he can't do it. He can't do it well. We're having protests all over. He was talking about Charlottesville. Charlottesville was a little peanut, and it was nothing compared, and the hate wasn't the kind of hate that you have here. This is tremendous hate, and we have a man that can't talk about it because he doesn't understand it. He doesn't understand what's going on with our country. He doesn't understand that all over the world we're being laughed at as a country because of him and his administration. And today we had, I hear, because I was forced to be here, and I'm glad I was because it was a very interesting day in a certain way, but the U.S. Supreme Court had a monumental hearing on immunity, and the immunity having to do with presidential immunity. And I think it was made clear, I hope it was made clear, that a president has to have immunity. You don't have a president, or at most you can say it would be a ceremonial president. That's not what the founders had in mind. They're not talking about ceremonial. We want presidents that can get things done and bring people together. So I heard the meeting was quite amazing. Quite amazing, and the justices were on their game. So let's see how that all turns out. But again, I say presidential immunity, very powerful. Presidential immunity is imperative, or you practically won't have a country anymore. Thank you very much. Thank you.
What's your response to Arizona indictment yesterday?
That is Donald Trump speaking after yet another day of court in his hush money trial. And again, we listened to the testimony, or I should say jurors listened to the testimony of David Pecker today. Donald Trump saying that the case never should have happened. He then pivoted to attacking Biden over what we are seeing, the unrest on college campuses, attack the economy, new economic numbers that came out today, the gross domestic product. U.S. growth did slow in the first quarter, but inflation did remain a concern. We should say, in terms of whether this case should have ever been brought, we should remind our viewers it was brought by a grand jury, Trump now being judged by a jury of his peers. Let me turn to NBC's Dasha Burns very quickly. Dasha, what was your takeaway? He also weighed in on the arguments before the Supreme Court today, saying it was made clear that a president has to have immunity. He was basically saying that's what his lawyers were arguing. He said the justices were on their game. But again, we don't know what they are going to decide. And by all accounts, they do not seem poised to give him the broad immunity that he is seeking.
No, I mean, it was a pretty robust question and answer exchange between the justices and lawyers, both for the Justice Department and for former President Trump. Not clear at all where this is ultimately going to land. There was a lot of skepticism of the arguments on the part of Trump's lawyers. And again, just a robust discussion like so many of these Supreme Court hearings are really fascinating. I also want to just fact check one other piece of information he said there, Kristen. He said that gas is $7.50 in California. I just did a quick search. According to the AAA average of California, it's actually $5.04, and I did not see it at $7 in any of California's counties. So still a lot of a high price for gas in that state, but not quite as high as the former president was talking about. But yeah, he did call the Supreme Court arguments amazing, saying that justices were on their game. And otherwise, he is really sticking to the message that we hear over and over again again when he talks to reporters outside of the court, just saying that this is unfair, that this should have never been brought. One thing we didn't hear from him today, at least in the remarks just now, is any attack on the witnesses themselves, which, as we know, has been a subject of controversy and is a subject of an attempt on the part of the prosecution to hold Trump in contempt for violating those gag orders. We are still waiting to hear from Judge Merchan on the motions that they brought up.
Dasha Burns, thank you for racing to a camera and for that great fact check and analysis. We appreciate it. Barbara McQuaid, let me go back to you, get your take on what we heard. Again, I thought it was notable that in addition to all of the rhetoric that we are used to hearing from former President Trump, he said it was made quite clear today that a president has to have immunity. Well, we don't know if that was made clear to the justices. What we know is that his attorneys were making that argument before the Supreme Court. What was your takeaway from what you heard from Mr. Trump?
This is a rhetorical trick that Donald Trump uses frequently, and that is to suggest that something is true when it is not. He suggests that that what Special Counsel Jack Smith wants to do is to take away presidential immunity, to change the status quo. And this was a line of questioning by a number of the justices, especially Justice Ketanji Brown Jackson, who said, what was the Ford-Nixon pardon all about if there was no ability to hold a president criminally accountable after he left office? Wouldn't it be a terrible place if a president didn't have to worry about the potential of being charged with a crime and thought he could use all of his powers with impunity without worrying about criminal responsibility? And so this idea where he says that we can't change a president's power, we can't take away his immunity, otherwise he would just be a ceremonial president, is not the way I think every president has thought about their job until now. And so it's a trick that suggests that this is an effort to undermine the power of the presidency as opposed to holding this president accountable.
Tim, what is your takeaway from what we heard? And again, Barbara underscores the enormity of the decision, the weight of this decision before the high court, the fact that what they decide will have implications for presidents to come.
I think it is that important. I don't necessarily think that, when he says that was made clear, it was probably made clear by his attorney, but I think it is going to end up being something where they're going to give a lot more guidance to future presidents as to what their left and right limits are. I do disagree with the idea that Jack Smith is trying to take away an immunity that's existed. I mean, it's one of those things that's kind of it's never been tested. And so it's never really been something that they've had to deal with. And so now for the first time, they're going to do something that probably would have been easier if the framers had done, as several states have done in their constitutions, of actually codifying it. But now we're at least going to have good guidance for every president going forward. I think it's something that some of the other rulings in this case, the pretrial rulings, I think are also going to come up later on as to what are the limits of executive privilege, because some of those rulings on grand jury matters essentially take that away to tell future presidents, hey, your successor can bring in the White House counsel to have them testify against you. And so I think that is something that is going to have to be decided by a higher court at some point in time as well.
All right. Well, thank you for helping us understand those breaking developments. We really appreciate it. Tim and Barbara, great analysis. We will have to have you back because these legal battles are ongoing. So thank you both so much. Meanwhile, we want to turn now to another of former President Trump's legal issues. Last night, Arizona Attorney General Chris Mays announced charges for a host of Trump allies, including his former chief of staff, Mark Meadows, and personal lawyer Rudy Giuliani for the so-called fake electors scheme in 2020. Mr. Trump himself is identified in the indictment as an unindicted co-conspirator. Now, the indictment includes charges of conspiracy, fraud, and forgery for individuals who aided the illegitimate election certifications that were sent to Washington claiming Trump won Arizona. President Biden carried that state by about 11,000 votes. Joining me now is NBC's Vaughn Hilliard, who is covering this story for us. So, Vaughn, break this down, yet another legal angle that we are following on this extraordinary day. These charges from the Arizona Attorney General, what are they? Who do they impact? And could they ultimately ensnare the president?
Right. This all has to do with that alternate slate of electors scheme. And notably, Chris Mays didn't come into office until last year, January of 2023. She won a close race in November of 2022. A Republican who did not investigate this scheme had served in the 2 years after the 2020 election. But what Chris Mays' investigation led to was a sprawling indictment, not only against the 11 actual electors in Arizona that included the likes of former GOP chairwoman Kelly Ward in the state, but also current RNC committeeman Tyler Boyer, who is also the chief operating officer of that Charlie Kirk group called Turning Point USA, but also the likes of Boris Epshteyn, right? Boris Epshteyn continues to have a prominent role in this 2024 campaign. He is somebody who has been the legal advisor to Donald Trump, but you've also got Christina Bobb named in this indictment. She was just brought on last month in a former role as legal counsel for election integrity for the RNC. And so these are folks that are still very much a key and active part of Trump's current political operation. Yet, for the efforts dating back to 2020, Chris Mays, over the course of her investigation, had made the commitment that she wanted to further investigate and potentially bring charges as a signal that folks should not break the law going into the future, Kristen.
You know, Vaughn, you take me to my next, and I think what is really one of the central questions here, which is how does this all impact Donald Trump? All of these people in his orbit have been indicted. He's an unindicted co-conspirator. But ultimately, what do these charges mean for him? Could he ultimately be indicted here as well?
It's a good question. It depends on the extent to which they could get cooperating agreements from some of these individuals. You know, you have Kenneth Chesebro, who we believe was somebody that was likely granted immunity from Chris Mays. He is not one of these defendants here. And so for Donald Trump, you know, this is not necessarily the end of this Arizona investigation here, but also the details that outlined in this indictment are quite significant, including one that John Eastman had placed a phone call to Rusty Bowers, who folks will recall was the Republican Speaker of the House at the time that all of this was going down. And the indictment alleges that John Eastman urged him to work with the state legislature to decertify Arizona's election results, send the Trump slate of electors to Washington to be counted, and then let the courts settle it from there. Of course, Rusty Bowers did not move to decertify the results, nor did Governor Doug Ducey, another Republican who met the scorn of Donald Trump. But this was ultimately an indictment that extended beyond just those 11 Arizonans, but one that really hits at the core of not only the past Trump operation, but those that are still have significant roles in his current team.
And Vaughn, just big picture, there have been indictments for the so-called fake electors in other states, from Georgia to Michigan, Nevada. How are those cases progressing? What's the update there?
Right. Those cases are progressing in Georgia and as well as in Michigan. And, you know, I think that the Georgia case in a lot of ways laid a foundation for Michigan and Arizona to bring these charges. But the Georgia Fulton County case, Fani Willis even included direct references to efforts by the likes of John Eastman and Kenneth Chesebro, alleged architects of this scheme, and directly cited in her lawsuit or conspiracy lawsuit the actions that they took in Arizona. And, you know, I think if when we're talking about the largeness of this, Kristen, you're dealing also with the fact that, you know, Donald Trump has not only not denied so many of the actions that took place, but in many ways, a lot of this happened out in the public eye, right? The Republican Party of Arizona, they literally videoed themselves signing this certificate that they went and sent to Washington. They didn't try to hide a lot of what is alleged in this indictment, but instead they embraced this as part of their effort to promote Donald Trump to potentially even be named the president on January 6th.
All right. Well, we will continue to watch closely as it all plays out. Vaughn, as always, fantastic reporting. Thank you for joining me. I appreciate it. We are going to have even more about all of the former president's legal issues with the panel. Plus, Senator Mitch McConnell meets the press. What the Republican minority leader thinks about Trump's claims of absolute immunity. That moment from my sit-down interview is after the break. You're watching Meet the Press now. Welcome back on this incredibly busy and also historic day. We have a great panel to break it all down. Joining me now on set is Molly Wall, senior political correspondent for the Wall Street Journal, Navin Nayak, executive director of the Center for American Progress Action Fund, and Brendan Buck, former aide to Republican House Speakers John Boehner and Paul Ryan. He is also an NBC News political analyst. Thank you all for being here. Where to begin? Molly, let me start with you. My goodness. We just heard from former President Trump, not a surprise, kind of typical campaign rally that we hear from him outside of the courtroom. He was basically making the case that he thought his attorneys made it very clear that presidents should have immunity. But this is such a significant moment, not just for him, but for all of the presidents who we will cover in the future. What do you make of what happened at the High Court today?
It was really a fascinating argument, and it was interesting to see how broad it was. You know, I think the justices had an opportunity, if they wanted, to keep this a very narrow case and only apply what they were talking about to this particular indictment. But because this is such an uncharted area in the law, and because courts have not been called upon to decide this kind of thing in the past, you know, not even Nixon sort of tested the system to this extent. And so you really see them, even the liberal justices saying, we need to set a precedent here that gives some guardrails, that says where the limits are in the law. So all of them asking these probing hypothetical questions, clearly aimed not just at deciding whether this particular indictment can go forward, but where the lines will be drawn in the future as future presidents perhaps also seek to test the system in this way.
Yeah, Navin, pick up on that point, because it seems like the justices are poised to, if they rule on this case, to find a much narrower ruling than a president is entitled to immunity across the board, but they also could kick it to the lower court. And quite frankly, either could be a win for former President Trump, because it means that this case is not going to go to court likely.
Yeah, I think it was pretty disheartening if you're, one of the many millions of Americans who do think that no one is above the law and that we should be holding everyone to the same standard and there should be a level of accountability. It was the argument that was made during impeachment proceedings, that the courts will hold them accountable. This was a clear signal that actually the courts are not going to hold Trump accountable and that he will evade any sense of accountability, it seems.
Brendan, what do you make of this? Because there's that piece of it, which means that voters might not have an answer to these court cases. There's another piece of this, though, which is that Trump has been in court 4 days a week. He's not on the campaign trail. He has been holding events on the weekends. But last weekend, his big campaign event got rained out, which was a reminder this is real time that we are talking about. What do you make of that?
Yeah, I mean, we'll leave it to the lawyers to talk about the legal precedents. And there are real consequential decisions made. So I think the Supreme Court should take this very seriously. What powers does a president have? Absolutely. But as a political matter, whether or not this goes to court is extremely important. Donald Trump, obviously being stuck in court is not good for him. He can't do rallies and things. But that being the context in which we see Donald Trump for months on end is not good for him. Really, I think really any context in which Donald Trump is the story versus Joe Biden is probably not good for him. And probably on the flip side, if it's all about Joe Biden, it's probably not good for Joe Biden. But if Donald Trump is able to avoid that, and he's able to now turn the page, get through the New York case, whatever the outcome may be, and get back to doing what he did after he came out of there, which is hammer Joe Biden over and over again, he'll be in a much better place. But that to me could sway the election, frankly, whether or not this court case actually goes forward.
Well, can I say, I thought it was so interesting. This is the first time I've seen Trump come out of court and actually talk about issues. Normally he comes out and he just rails on the court.
Yes, great point.
But this time, he talked about foreign policy. He talked about gas prices. Clearly someone has gotten to him and said, voters don't like to hear you just whining all the time. But you are winning on a lot of these issues, because he is winning on a lot of these issues when he can bring himself to talk about them and not just his personal grievances.
It's a really great point. Look, I had the opportunity to sit down with leader Mitch McConnell earlier today. I asked him about this because, if you'll recall, during Trump's second impeachment, McConnell voted to acquit him. And he said, ultimately, it's going to be up to the courts to decide what happens to Donald Trump. I want to play the exchange and get everyone's reaction on the other side. Let's talk about what's going on at the Supreme Court this week. In 2021, you voted to acquit Donald Trump in his second impeachment, saying on the Senate floor, quote, We have a criminal justice system in this country. We have civil litigation, and former presidents are not immune from being held accountable by either one. As we sit here, Donald Trump's attorneys are arguing before the Supreme Court that presidents are immune from criminal prosecution for actions that they take while they are in office. Do you agree with that argument?
We're going to find out, aren't we? I mean, the Supreme Court is going to deal with that direct issue that I was referring to on February 13th of 2021. And I think we'll find out sometime soon.
What do you think, Leader McConnell? Do you think that presidents should be immune from criminal prosecution for actions while they're in office?
Obviously, I don't think that, but it's not up to me to make that decision. The president clearly needs some kind of immunity, or he'd be in court all the time. So we'll see how the Supreme Court deals with it.
Just to be very clear, you said former presidents are not immune from being held accountable. You stand by those comments?
That was my view, but I don't make that decision.
But you stand by those comments?
I mean, that's my view. But my view is only my view. I mean, the court is going to decide this.
But just to be clear, you stand by those comments. Former presidents are not immune from being held accountable.
Yeah, I do, but many times I have to say I'm not on the Supreme Court. I don't get to make the final decision on that.
Molly, he ultimately said, I do. I stand by those comments that presidents do not have immunity, although he did say they should have some kind of immunity. So it seems like he would support a narrower finding, but he was very clear that this is for the courts to deal with.
Well, and poor Mitch McConnell, right? You keep saying things that don't seem controversial at the time, and then it turns out they become that way. And you did a very good job pinning him down on that. But, you know, it's been very interesting to see Leader McConnell become sort of liberated now that he's announced his upcoming retirement. He clearly feels that he has the ability to say what he really thinks, even if he's hedging it quite a bit, having also, you know, endorsed Donald Trump for president. So we'll see if the Supreme Court agrees with Leader McConnell or not, but he stands by what he said after January 6th, and he had some very harsh words for Donald Trump after January 6th.
Yeah, I thought it was really a significant moment. Brendan, what did you make of this? And you, of course, have worked with Leader McConnell in your capacity of working with the former speakers of the House.
As somebody who's retiring, of course. Yes. So to me, it felt like somebody who was sort of sick and tired of defending Donald Trump. Like, here's my view. This is not my problem anymore. I mean, that's kind of how I read it. Right. He does have, as a conservative, he has an expansive view of powers that the executive should have and should not be challenged. So that's not surprising that he says there should be some immunity. But he also is the ultimate political animal, and he knows that if Donald Trump has a really bad day, his goal of taking back the Senate is in jeopardy. So he's not going to throw Donald Trump under the bus as much as he probably wants to. We know he doesn't like Donald Trump, but he also has other priorities.
Navin, what did you make of what we heard?
I mean, I think it was at least heartening because that was his statement during the impeachment. So he at least stood by it and didn't switch. I think it is, to me, it's sort of a reminder of the rift in the party, right? And we saw it earlier this week with Ukraine. There is a real divide going on in the Republican Party, and for the most part, McConnell is winning. Maybe this week he had a better week.
Well, you're fantastic.
I mean,
you take me to my next point perfectly, which is about the rift in the Republican Party to some extent, because I asked Leader McConnell about the fact that Ukraine aid, after 6 months, was passed. Of course, Leader McConnell, one of the people who led the charge, arguing to his party that it needs to be passed, not just for Ukraine, but for the national security of Europe and ultimately of the United States as well. So it has been viewed as a big victory for President Biden, for Leader McConnell, for Speaker Johnson. He had a chance to talk to President Zelensky of Ukraine today. I asked him about that conversation. Look. I see you have your tie on with the Ukraine colors. I understand that you were able to speak with President Zelensky today. What was his message to you?
Well, he was grateful because he knew that the big challenge was on my party. And I think it was nice of him to mention that we had a bigger vote than we did a couple months ago. I think there's a growing feeling in the Republican conference in the Senate that the isolationist path is not a good idea.
Molly, ultimately, we have a robust exchange about the isolationist path and whether it's dwindling or whether it's just becoming stronger within the Republican Party. But it speaks to Navin's point that there is this real divide in the Republican Party.
It's a generational divide, and you see it playing out in the Senate. And when I spoke to Leader McConnell after that first vote, when less than half of the Republicans supported this foreign aid package, he said the same thing. He said that he did not believe that this was something that was on the march in his party. And interestingly, just to tie it to the other part of the conversation, you know, this has been a huge legacy issue for him. Yeah. But when you ask him what his principal legacy is, he says the Supreme Court. And this is very much Mitch McConnell's Supreme Court that is deciding Donald Trump's fate.
That's a fantastic point. Brendan, what did you make of that? Do you feel like isolationism is retreating within the Republican Party, or is it the opposite?
I don't. And I actually think to a larger extent, he's losing the argument between Donald Trump, what the party is going to be. But this is one last thing. He's clearly very proud that at least the one thing that he could do before he's out, he was able to save something.
Yeah, this was a victory lap for him, and I think it'll be his last one in the party.
Yeah. All right. Well, thank you all for a great panel. Really appreciate it, Molly, Navin, and Brendan. Great conversation. We will be back tomorrow with more Meet the Press Now. And if it's Sunday, we'll have much more of my interview with Senate Minority Leader Mitch McConnell. NBC News Now special coverage picks up with Hallie Jackson right now.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.